Good morning, everyone. On behalf of the Real Estate Board of Greater Vancouver, I'd like to thank you for joining us today for our Land Ownership Transparency Registry event. This is the first event in a series on this new registry, which will follow as we get more detail on how the registry is being implemented. By way of background, the board, together with BCREA and other real estate boards, expressed concern to the Real Estate Council about some of the guidance they were proposing to give you about using the new registry. The council listened to us and is working on improvements to their guidance documents. We hope to see the new and improved version in a few weeks, and we will do a further webinar when we get that information. For those of you who may not know me, I'm Harriet Permit of the board's Government Relations Manager. Before I introduce our speaker, I'd like to go over some housekeeping items. We'll do a Q&A period after Bijan has presented. We'll try to get to as many questions as we can. You can type your questions in the Q&A section found in the panel at the bottom of your screen. You're going to learn a lot today, but don't think you need to memorize everything. You'll be sent a copy of the presentation in the next couple of days. Before we move on, I'll just mention a few upcoming events that you might be interested in. On February 17th, on the circular economy, how to meet the needs of a sustainability or eco-conscious client. February 19th, on what realtors need to know about radon gas. And February 24th, on COVID-19, looking back and looking ahead with Dr. Patricia Daly, the Chief Medical Health Officer for Vancouver Coastal Health. That should be a good one. You can register for these through the events page on rebgv.ca or by using the links in the newsletter emails you get from us or via the member Facebook posts for the events. Now on to our presentation. I'd like to introduce our speaker, Bijan Ahmadian. Bijan is the real estate lawyer and the founder of Bijan Law. He works with realtors every day, helping them to structure deals, conducting due diligence, and doing closings. He and his team have extensive experience working on both residential and commercial real estate transactions. Welcome, Bijan, and I'll turn it over to you.
Thank you, Harriet, and thank you to the board for inviting me. I have been looking forward to this presentation today, and thank you for that warm introduction. I will start off by telling you a bit about myself, a little bit more. I've been a real estate lawyer since 2013. My team and I work in both residential as well as the commercial space. We help realtors structure deals, do all the closings. We also do litigation of real estate matters. And often we get calls from realtors asking us how to draft a subject, how to deal with an issue. And we are often the folks that advise those realtors on how to protect themselves and their clients. These days, one of the questions we're getting is about the Transparency Act. So folks call me and say, look, my client wants to buy a property through a corporation. And up until now, he thought that, or she thought that if she uses a corporation, that nobody will find out her real name. But it looks like with this transparency registry, that is going to change. Is that correct? And the short answer always is yes, that is going to change. My goal today is to tell you how that's going to change things, how that might affect your day-to-day practice. But like Harriet says, it's important to note that what I'm about to present today is preliminary information on this topic. There will be additional workshops once additional functionalities of this system becomes available. So there are, at this point, certain things we don't know about the system. And more guidelines with respect to how your practice will change will be forthcoming from the board, I am sure of. But in the meantime, my hope today is to give you an overview of what this registry will do and how it will, in a practical sense, change the way that you will practice. your roles as the broker of deals between buyers and sellers in both real estate and in business world. Okay, so in order to tell you about the transparency registry, what I thought I would do first is give you examples of two registries that you are already familiar with. So these are two types of registry that you already use, and I'll take you through them, tell you what the function is, so that when we come to transparency registry, you have I can try to use the two examples as a stepping stone. And the reason I'm doing that is because the transparency registry is something that's completely unfamiliar to folks. Whether you've come from, whether you've been working in DC, whether you've come from another province or another country, it's unlikely that you have seen something like this. It's been a challenge for me to figure out, and for a lot of my colleagues to figure out exactly how we navigate our way through this. And so in order to explain it, I have decided to really try to simplify it and draw some analogies so that it's easier for folks to understand what it means. The two types of registries that you are using on a day-to-day basis, and you're quite familiar with them. One of them is the land title registry. So what you do is you go in and put a PID of a property, and that's your input. Your output is that you get a title with the names of the title holders, the registered owners, in other words, and you also get their occupation and their address. These are the identifying information that then allows you to go and verify the client, identify the client, and so on and so forth. So a registry is a place where you provide certain inputs like the PID, and it gives you those outputs that I just listed. Now, if you do a title search and then find that the registered owner is a corporation, the next registry that you are likely to use is the corporate registry. You would put the name of the title holder there, and the output is what's called a notice of articles. The notice of articles will tell you who are the directors of that corporation. In other words, who are the authorized signatories. You are used to using both of those registers. It's usually the listing realtor that when approached by somebody to sell their property, goes and does a search in those registries, finds the pertinent information, and starts putting the package together. And my understanding is most selling realtors don't do the search themselves. Some do. Some of them just get the search from the listing realtor. But regardless of the practice, those are the two registers you're familiar with. Now, let's turn our mind to transparency register. It's called a transparency register because it's supposed to make something transparent that wasn't transparent up to this point. So let's go back to the example I just gave you with respect to the corporate registry. When you do a corporate registry search, you get the name of the corporation, you get their address, registered and records office. You also get the name of the individual directors and the addresses of those directors. But what you do not get is the name of the shareholders. The shareholders are people who are the actual owners, and typically in a real estate transaction are typically people who have the money and who are the source of the funds behind the transaction. Those names do not show up on a corporate registry search. They're typically kept in something called a minute book. And the only person that knows about the registered owners of the shares is Canada Revenue Agency when the corporation files its annual taxes, which some corporations may delay the first filing of. So from the time a title gets registered under a corporation until the CRA finds out who the shareholders are, it could easily be a couple of years. And so the idea of a transparency registry was to stop that and to bring to transparency, bring into transparency the names of those shareholders. Now, what's the reason for that? Why do we want to identify those shareholders? The policy reason for this, and I'm just telling you what the published policy reason is. Some of you may agree, some of you may disagree with the reasons behind it. But the Transparency Registry came out of the government's study as to how to create affordable housing. And there were a number of plans. One of them was, as you all familiar with the foreign buyer tax, there was the speculation tax. There were a number of methods. And one of those methods was a transparency registry. The thinking is that BC became a place where people can park their money, can bring their money without anybody being able to know that, by hiding behind a corporation. And therefore creating what the policy paper calls a hidden ownership. So the thinking was that if we bring this hidden ownership into transparency, so if we disclose who the real shareholders are, that those shareholders are less likely to want to bring their money to BC. Maybe they'll go to other jurisdictions. Maybe other jurisdictions will follow suit, and maybe they won't have any place to go. And BC stops becoming as attractive to those folks that are looking to hide their identity. And that will decrease the demand and will cool down the market. Whether that works or not is outside of the scope of this workshop. I'm just telling you the policy reason because I think it's important for you to understand why this transparency registry was created, or what's the functionality behind it, what's the reason behind it, so that you can start to appreciate it when you start working with it. Again, the reason I think it's important to discuss these is because this is unprecedented. We don't have something similar to this elsewhere in Canada, as opposed to the land title registry and corporate registry that are common. You expect that you will be able to do a title search and find who the owners are. Okay, but you typically don't expect to be able to do a title search and find out who the shareholders behind the corporation are. So I think it's important to go over some of the reasons why this was created, so that it creates the context that's necessary for the rest of our workshop. So basically, the idea is to remove hidden ownership. And the thinking is that if you remove hidden ownership, you will decrease demand and the prices will go down. Okay, so if that's the idea, now let's just talk about how it affects your day-to-day role as realtors, whether you're a listing realtor or a selling realtor. In reality, the actual forms and conveyancing is being done by the notary or the lawyer's office. And so you won't get involved with that element of the transparency registry. But when the search becomes online, which is expected to happen right now, it's scheduled as of April 30th, that can bring new responsibilities and duties to a realtor. Now, to explain what that looks like, I want to draw for you what two examples are of how the transparency registry will make things more transparent, okay? So I'm gonna start with the example of a corporation first, and I'm gonna draw this on this board behind me. So as I mentioned, when you do a corporate registry search, you only get the names of the directors. You don't get the name of the shareholders. So let me just bring myself up here so that you can see me. So let's just say we have a corporation. This is what some people refer to as the number co, as the hold co. So this corporation is owned by a shareholder. So it's a human being that's up there, and it's going to own a piece of property. I'm going to draw that with a house. And there is another set of persons that are, I'm going to call them directors. This is publicly available. The shareholders is right now hidden. This you can see, this you cannot see. So what the transparency registry is going to do is going to create a system every time we file a conveyance to transfer this title. We have to skip over the corporation, find out who the shareholders are behind the corporation. And if they own more than a certain amount of shares, they become what's called an interest holder. They fall within the meaning of interest holder. And then we have to include all sorts of information about them. What's their name? What's their date of birth? What's their address? Are they a resident of Canada for income tax purposes? Are they citizens of Canada? And also, what's their social insurance number? So all of that information goes to the government, and they know that this property is actually linked to this person. Now, keep in mind, when I say all this information goes to government, I am talking about the provincial government, okay? Because up until now, this information was available to Canada Revenue Agency, because like I told you earlier, when this corporation files its income taxes, it discloses the name of these shareholders to Canada Revenue Agency, including their SIN number and their addresses and so on and so forth. So CRA would know at some point, which could be as soon as this corporation decides to file its taxes, it could take usually sometime at least 1.5 years to 2 years later when the corporation finally gets around its bookkeeping and files it. It's due 6 months after its first annual year. So nobody would know the link between those two for quite a while. Whereas right now, as soon as the title is transferred, as a result of the transparency register, this information also gets filed at the same time through a declaration. And so Mr. John Smith now, who usually used to enjoy this privacy because being a shareholder now, his name is going to be on this transparency registry. And anybody searching for John Smith, the shareholder, will be able to see this property and the PID that's this property, and they will know that John Smith owns this property. So going back to the reasons why this was created, if privacy is important to John Smith, knowing that by coming to BC, they are going to not have the privacy, it's possible that John Smith may decide to go to a different jurisdiction, decreasing demand, cooling down the market. That's the thinking behind it. Okay, so that's one example of how disclosure would have to be made and a transparency register comes into play. Now let's look at another example that we see commonly, which is that you don't have a corporation on title, but rather you have a person on title. So I'm just going to draw that same house, and I'm going to make sure that I'm within the screen. Yes, I am. And here, instead of having a corporation, you have an individual that's sitting on title. So the person that's sitting on title, typically we call them the registered owner because they are the ones that are on the registration. Okay, but we do know that sometimes the registered owner is not the same person as the person that truly has financed this. There's somebody else behind the scenes sometimes that what we call is the beneficial owner. Okay, so there could be somebody else behind the scene up here that, just gonna make sure I'm in the screen so that this is the beneficial owner. Okay, so the beneficial owner is the person who's basically the dollar guy. And you may have heard of the word bear trust. The relationship between these two owners is a trustee relationship, and typically it's papered, if it is papered, in the form of a bear trust. The bear trust agreements typically say that the registered owner is there as a nominee, as a trustee, holds the title in trust for the benefit of the beneficial owner, will not do anything with the title without the beneficial owner's permission, and the beneficial owner is responsible for everything. Why do people do this? We know that in the real estate world, this kind of transaction happens for a range of reasons. Sometimes, an elderly parent wants their child to be the registered owner so that the child can look after all the matters with respect to the property. Sometimes it relates to mortgages. Because somebody qualifies for mortgage and somebody doesn't. So the beneficial owner asks a friend, a relative, their child or their parent to become the registered owner. They tell the bank that, okay, this is the registered owner, and that person goes and gets a mortgage, but the beneficial owner is the one who has funded this deal. And it's important for me to say immediately that that's in breach of every bank's mortgage terms. I don't advise my clients to do that. Neither should you. But we know that that's a practice that's prevalent, and it's behind the scene. Nobody knows about this relationship. However, as a result of the transparency register, what has to happen is that the registered owner must now disclose that they are just a registered owner, that there is a beneficial owner behind the scenes. So I'm going to call this registered owner again, John Smith, and let's call the beneficial owner Cassie. So if there's a bare trust agreement between Cassie and John Smith, what that means is that John Smith is on title. When you do a title search, John Smith comes up. And today, before the transparency registry, you would have no way of knowing about Cassie. Cassie's name would not be on title. Cassie's name would not be anywhere. But as of now, or as of November, when we started uploading information into the transparency registry, if you have a relationship like this relationship has to be disclosed. Otherwise, you're in contravention of the act. This registered owner is in contravention of the act, and there will be penalties. Now, there are some mechanisms that come into play with this that you have to be aware of. As of November 30th, 2020, so last November, we started including transparency declaration and reports with every single filing, because the land title office has the right to refuse registration without them. So information has started to get uploaded into the transparency registry. It is not accessible yet, but it's getting uploaded up there. The next important timeline that's coming up is on April 30th, when you're supposed to be able to search things. And the search is expected to have two interfaces, one that's available to the public and one that's available to law enforcement and everybody else. The one that's available to the public is not going to have all the private information like the SIN number and the social insurance number that I told you we upload. But it's expected to have at least the functionality where you put in the PID of a property and you find out who the interest holders or the shareholders or the beneficial owner is. The other functionality that is expected to have is that you can put in an owner's name, like John Smith or Cassie, and find out what properties they have an interest in. So those two searches are expected to be available to everybody. So anybody with internet, over in some of the country can do a search and find out what somebody is owning in British Columbia. That's April 30th. There's a third deadline that's coming up that's important, and that is November 30th, 2021. So that's November of this year. Everybody who did their transaction before last November, so when the transparency register was not available, must now file their transparency declaration by November of this year. So every transaction that was done before November, when we didn't have that system, where there was a relationship between a registered owner and a beneficial owner, those people need to go back and they need to file. Every corporation, every single corporation that's on title, they need to go back and they need to file a transparency registry, a transparency report. And there are penalties for not doing so. The penalties are $25,000 for individual and $50,000 for corporation. However, that is only if those numbers are less than 5% of the assessed value of the property. So the government is going to take a larger number, 5% of the assessed value of the property, or $25,000 in terms of individuals and $50,000 in the case of corporation. And so those penalties can be quite hefty, especially given how expensive real estate is. On a $1 million condo, you'd be looking at $50,000 right there. On a $10 million commercial property, you'd be looking at $500,000. And so the penalties can be quite high. So it's not going to be unusual for clients to reach out to you, because you are their first point of contact, and say, okay, what do I do about this? This is the first question will be, how do I get around this? And you don't have any answer as to how to get around it, because we can't advise people, we can't assist people on how to get around the law. The law is the law, and we have to comply with the law. But it does give you some duties that I think you need to be aware of. Now, what I'm about to tell you in terms of your duties are things that haven't been tested in court, because this piece of law is very new, but are things that I think will come up within the next few years. And I don't think that any one of you wants to be the test case. So I'd like to bring some of these practical issues now to your attention, so that if you're faced with listing a property or buying property for your client, and now you have this additional tool, this transparency registry, you know how you can use it in order to basically identify problems with the transaction. So right now, if you're acting for a listing realtor, let's start with the listing agent first. What you're going to do is you're going to do a search on the land title office. And if you're finding that a corporation is listed, in all likelihood, you can stop right there. You don't have to go to transparency registry, because a corporation is run by its directors. The directors have the authority to tell you what to do with the property. So you can do a corporate registry, you find out who the directors are, and in my opinion, right there and then, you can basically stop your search and say, look, the person that I need to identify is this director. This director has the authority to tell me what to do with the property. I don't need to care about who the shareholders are. The law in BC is fairly settled that the shareholders have no ownership in a property. And so even if you know who those shareholders are through the transparency registry, in my opinion, that shouldn't give rise to some new duty that you should have. However, if you look up the title, and if you see an individual is registered there, I highly recommend that when the transparency search becomes available, that you also do a search to see whether the name on the registry, on the transparency registry, which would be the beneficial owner, is different than the registered owner. In other words, you find that John Smith is on the title, and you go into transparency registry to see if there's a Cassie behind all of this. Now, if there is no Cassie, there's no problem. You've just got a registered owner, you go identify them, you get instructions from them, you sign the listing agreement with them, that's the end of it. But if there is a Cassie, then an argument can be made that you had access to and you had knowledge of this Cassie being there, and should have made an inquiry about whether or not Cassie is giving you authorization to list the property and to attend to execution of the contract of purchase and sale. That's a new thing that you wouldn't be even aware of prior to Transparency Registry being there, because up until now those bare trusts were hidden. You dealt with the registered owner. You had absolutely no way of knowing that there is a beneficial owner behind ownership of a property. So this Cassie person could potentially bring a claim against you saying, you knew I existed. Why didn't you come and get my permission to list the property? So this claim would be similar to there being, for example, 2 registered owners on the property. If you had 2 registered owners on the property, you wouldn't just get one person's signature for your listing agreement. You would get both people's signature for your listing agreement. If you only went ahead with one person's signature, the other person could come and say, bad realtor, why didn't you get my signature? So now that you have access to this transparency registry, if another name comes up in your search, it's natural for that other person to have a claim against you. Now, you may have a number of defenses, and I expect that one of the defenses that lawyers will bring forward is that the transparency registry, believe it or not, allows the person making the filing to make the choice that they were not able to confirm the information. We don't know whether you will be able to see that when you're doing a search, but the transparency registry by design can be inaccurate. That's as opposed to the land title registry, that is something you can rely on. You can say that this is what we call an indefeasible title. If somebody's untitled, that's it. You can rely on it. But with the land transparency registry, that is not the case. But by design, inaccurate information can be filed. Now, there are penalties and all sorts of things. But one of your defenses as a realtor could be, look, I didn't have to rely on this information because it can be inaccurate. Now, whether that defense would work or not, we don't know. What I'm saying is you don't want to be the test case. So when the search becomes available, it's a $5 search. I suggest that if you see a person on title, that you do a transparency registry search. If you see a different person on there, then you should immediately seek legal advice and ask your client to seek legal advice. Definitely bring it to the attention of your managing broker and say, okay, what do I do here? Because there's this other person that potentially is an owner of the property that's not listed on title. And I'm worried that this other person is going to come make a claim and say, why didn't you get my permission to list this? Of course, if you get their permission to list it and you identify them and take them through all the regular routine as if they're a registered owner, then you're okay. And I want to again review why you don't have to do that with a corporation, because in a corporation, the shareholders are not owners of the property. Here, the beneficial owner is an owner of a property when it's individuals. So it's just the way that our corporate law works that creates an extra burden of responsibility for you, an extra duty when you see an individual that's listed on title. Now that was basically the role of a listing realtor. Now let's talk about a buying realtor. So let's just imagine that the listing realtor did not do this transparency search, and then the buying realtor brings their client forward, brings an offer, and the offer is accepted. They're in their subject removal, doing reviewing titles and those routine due diligences. One of the due diligence I highly recommend that the buyer realtor does is do a transparency search as well. Because again, if you see the registered owner is there and a beneficial owner is also there, that's different from the registered owner, then you should be advising your buyer client to seek independent legal advice immediately. Because it's possible that now that this beneficial owner's interest is public, that that person can potentially bring a claim and say, I was here, everybody knew I was here, about me. I was traveling and I wasn't aware of this. But you guys went ahead and dealt with the registered owner, whereas you knew that I had an interest in this and you completely ignored me. I think there is merit to that argument. I'm not saying that that argument will be successful because, again, this is new and hasn't been tested in front of a judge. But I'm saying you don't want to be the test case. And that's why it's important that for a $5 search that you do the search. Because if I was that client, if I was your buyer client, and I knew you could have done this $5 search and bring something to my attention, and you didn't, I would certainly add you as my realtor to that lawsuit. And then dealing with it becomes a gigantic headache. If you are the buyer agent, I would say do that search as quickly as possible so that if information becomes available that is as such, then you have time to get some advice and figure things out before your subject removal period runs out. So that sort of gives you an idea of what a listing realtor versus a selling realtor's responsibilities may change as a result of these transparency registry. Going back to the forms are going to be completed by lawyers and notaries when they do the transaction. So you don't have to do anything with the actual filing. However, as it's been mentioned, FINTRAC is asking that realtors do a beneficial owner search when they are dealing with real property. So one of the benefits of a transparency registry now is that when you are going to carry out that duty of doing a search of a beneficial ownership, you can do so by searching the transparency registry to see if there is a beneficial owner behind the scene. So that is sort of where I'd like to leave it in terms of my presentation and my content. I see there are lots of questions that are coming in. And as I mentioned to Harriet earlier, I'm happy to answer questions about the transparency registry to the best extent I can. A lot of it is new and we are learning about things as we go along. So it's important, again, to be reminded that that is going to be an upcoming workshops and series of many workshops to come for you to figure out what your duties are going to be in practice. Once searches are public, then we could do a presentation with PowerPoint and screenshots so that you can see exactly what you will have to do. So in the meantime, you can ask me about transparency registry, or you can ask me about anything related to real estate transactions, residential or commercial, and I will do my best to answer your questions. If we don't get to all your questions, my email address will be available to you and you can contact me by email and I'd be happy to respond to folks as soon as I can.
Okay, so we'll open it up to some questions now, and people are already using the Q&A box, so that's great. We'll get to as many as we can. We may not have time for them all, but we'll manage that process. We don't lose it because we're recording the session. And so, okay, some of these questions I'm sure the answers will probably be more in the material that has to come from the council yet. They're pretty specific, but we'll see how far you get with them. If you can't answer, then just say. So one question from Cameron: what happens if the owner of the corporation is another holding company? Would the shareholders on the transparency registry show the shareholder as the other corporation?
Okay, so that's a good question. Thank you very much. So basically what we have is that we could have another corporation here that's the shareholders of this corporation. The way the transparency registry has been designed is that we have to skip through all of the corporate layers and get to the person with the beating heart. And so the way that the forms work, the way that we are instructed as lawyers and notaries to fill out these forms is that we have to put a human being name at the end of this corporate registry form. So we have to follow the trace through all the corporations, find the beating heart, and put that shareholder's name in.
Okay. From Frida. It's a question about Crown-owned land. If the Crown owns all the land in Canada, how do you define the term? Like, what is the relevancy of Crown land to this process at all?
So that is exempt from this. There's certain lands that are exempt from this, and one of them is the Crown land. So Crown land would be land that's owned by basically the government, and that does not need to go into the transparency registry.
I think First Nations land as well are exempt.
Absolutely, yes. First Nations land also exempt, yes.
Yeah. Okay, Wendy says, are only corporation owners required to file by November 30th of this year?
No, everybody is required to file. Everybody who will, who's obligated to file. So let's just talk about who has an obligation to file. Corporations, all of them have an obligation to file, no question. As far as individuals are concerned, only those individuals who are not the beneficial owners, those individuals, in other words, who are trustees, those are the individuals that are supposed to file. If the individual on title is the beneficial owner, there's nobody behind it, there's no corporation, there is no trust, there is no partnership, that they're not holding the property in trust for somebody else, they don't have to file anything. Okay? So in terms of corporations, everybody has to file. In terms of individuals, only those who are trustees have to file.
Okay. From Doug, if you own any shares in any corporation that owns a piece of real estate in BC, will you be included in this? Furthermore, as shares are bought and sold by different parties, does the corporation have to continually update that information?
So the answer to the second question is yes. The corporation has a timeline. I don't remember exactly what the timeline is. It might be 90 days, but don't quote me on that. But it has to be updated as the shares are bought and sold. And the answer to your other question is that there is a threshold of how many shares you have to own in order to be included on the transparency registry, but it's a little bit more complicated than that. So I'm just going to take you through some of the details. So you have to be what's called a corporate interest holder in order for your name to show up on that transparency registry. And a corporate interest holder is somebody who owns a certain number of shares, but could also be somebody who owns very few shares, maybe even 1% or only one share, but who has the power through a shareholder agreement to appoint a director of the corporation. And so sometimes you see shareholders coming together, somebody owns very little, maybe 5%, which would not put them typically on the transparency register, but they have the ability to appoint a director as part of a shareholder agreement, which would then switch them into the corporate interest holder category, and their name would have to be listed. So to summarize, it depends. It's not just based on how much share you own, it's based on how much share you own and based on what kind of powers you have as a shareholder within the corporation.
Okay, so we have a question from Parisa. Is the beneficial owner registered somewhere related to a property? If they're a guarantor, it will show up in bank records and it's not a breach of the mortgage. So what is the position of a guarantor?
Okay, so sometimes you might go get a mortgage and the mortgage will have a borrower name. The borrower name is the same as the title holder, but on the Form B mortgage, you may have an additional name that's a guarantor, but typically the guarantor is not a property owner necessarily. It's actually, they're not, they are simply a guarantor. And so it would be in breach of mortgage terms if their guarantor is behind the scene a beneficial owner. A guarantor is supposed to be somebody who guarantees performance by the owner who's the borrower of their debt obligation. That's all they're doing. They're not supposed to be an owner.
Okay. So actually I have two questions here. They're related. is a 1% owner to be considered a beneficial owner? And the other question was, or is it only a major shareholder? Like, you know, the notion of major versus 1% or some lesser amount.
So the word shareholder, sometimes we refer to shareholders within a corporation structure, okay? But sometimes when people talk about shareholders, they're talking about this structure, and they think of shares as in how much of the property I own. So let me just address both different structures, okay? If it's a corporation and you truly have shareholders, then the person that just has 1% does not become a corporate interest holder because they own too little shares, unless they have the power to appoint directors or exercise control over the corporation because they have an agreement that says so. So the way that corporations set up is that a shareholder has rights to profits that may be very different to their rights to vote. Okay, when you watch these TV shows where people come and make these pitches and they say, look, I'll send you to 10% of my company for $1 million. You are only talking about the profit typically. You're not talking about control. But when you think about a corporation, you have to realize that shareholders have different sets of rights, and two of them that are very critical are right to profits and right to vote. The way that the transparency registry works is that it deals with the right to profit, which is how much interest you own in a corporation, how much shares. That typically is indicative of how much profit you're getting. Not always, but typically. So if you own only 1% and you're only supposed to get 1% profit, you don't end up on the registry. But you may have powers that is the same as somebody who owns 20%, 30% profit in the corporation. And if you have those powers to appoint directors to control the affairs of the corporation, then you would end up on the transparency registry. Okay, so you have to keep that in mind. Now, in terms of if when you talk about shareholders, what you really mean is this is structure. Yes, then even somebody who owns 1% as a beneficial owner, they are their name has to be disclosed. Now, typically, a lot of these 1% owners are already on title, so it should be okay. But if they're not on title, if for some reason somebody owns 1% of the property, they're not a registered owner, but they're a beneficial owner, then a transparency registry has to be filed, and that person's ownership has to be disclosed. And again, this is something that you can send a client to us. We can look at their structure. We can advise them as to what kind of filing they have to do. If they don't have to do any filings, then we'll tell them that as well.
Okay. We've got a question here from Stephen Gammer. Stephen's a commercial realtor. So how does any of this duty to be transparent apply to leasing?
Apply to leasing? No, this is about okay. So I was wondering it would be good to get a bit of a clarity on that, because are we talking about leases as in tenants, or are we talking about leases as in it's a leasehold as opposed to a freehold?
Probably about tenants, giving that it's from Stephen, I suspect. Yeah.
Okay. So basically, no, this deals with the ownership of the property and doesn't deal with tenancy. But if you had a leasehold versus freehold, we could have a different conversation about that. Okay.
We may have to at some point, but yeah, I suspect some of this will come through with the guidance from council, but they're all good questions. So Feroz, do we have to do a title search plus check the registration at the land of the transparency registry and pay double the cost?
The answer is yes, because now you have this search available to you, and a very good argument can be made that if you do not do this publicly available search and not warn your client about information that could potentially be relevant to their sale or their acquisition, that you would be in breach of your professional duties. And whether that argument would be successful or not, I don't know. But all I'm saying is that you don't have to be the test case. And I think it's $5 to do the search. So it's not as expensive as the land title search, which I believe is about $11. So you're not doubling the cost, but yeah, your cost is increasing by about 50%.
A related question from Mitra: does the transparency registry information appear on a title search?
No.
No. Okay, they're two completely separate things, and you have to do both. Basically.
Right, exactly.
Okay. They're both run by land titles, though. Okay, the land titles is going to be running the both registries.
Yeah.
Okay. Oh, here's a question from Amir. If the registered owner does not declare that there's a beneficial owner as well, how can government find out about it? Is the act relying on the parties involved to be ethical enough to comply with the act? Yeah.
So a lot of our systems, our legal systems rely on that. Like our income tax system relies on people declaring their income. Yeah, how could the government find out if somebody doesn't declare income? The same system applies here. How could government find out if somebody doesn't declare the beneficial owner? I don't know. Those are sort of enforcement things, and the government has their own secret sauce that they don't tell everybody else. Their own algorithms of how they might detect things and ask questions. All I can tell you is there's a penalty. If somebody doesn't file it and they are caught, then it's a $25,000 minimum for individual, $50,000 minimum for corporation, and 5% of the value of the property, whichever is higher, basically is the penalty. So, and if your client has a question about whether or not they need to file, we'd be happy to talk about it with them. You can tell your clients that what the conversation they have with their lawyer is privileged, is protected by confidentiality. So your client can come to me and say, I would like to, I have this situation, I don't want to declare. I can advise them about what the consequences are, what their options are, and that information that stays in this room with me, doesn't go anywhere. And so they can come get that advice, and you then don't have to worry about giving that advice yourself. You should be sending your clients to a lawyer, because the conversation they have with their realtor is not protected by privilege.
Right. Okay. Here's one that's kind of a transitional question in a way. What happens if you list a property prior to April 30th and the registered owner, an individual, has executed the listing? After April 30th, will it be required, or is it advised, that we do an additional search to confirm there is a beneficial owner? And if there is a beneficial owner, what needs to happen?
Right. Yes. As long as you have an active listing after April 30th, I would highly recommend that you do a search. If there is a beneficial owner, then the first thing to do, I'm assuming that between now and then, there will be some guidelines that will come out about how you're supposed to deal with that. So hold on to that question. But presumably, you would advise your managing broker, and you might call someone like me, who's a lawyer and who can give you advice about what to do. But definitely do the search.
It's always a good practice, even if you don't need it. You never know what you find, right?
Right.
Okay, from David, do we as agents do the search, or does the brokerage or office do the search, the title search?
I don't know about that, because that would be your practice within your brokerage. However you would usually do the title search, you would do this in the same way, whether it's your brokerage, somebody in your conveyancing that does it for you, whether you log in yourself, it would be the same process probably.
Yeah, that's kind of the question. Okay, oh, this one's interesting. Will the Transparency Registry impact properties held in family trusts? Will there be any impact on shareholders of cooperative properties where there are not individual title holders?
So the answer is yes to both of those. And how that will impact is going to be a very, very interesting question. I have read the definition of interest holder and a corporate interest holder and a relevant trustee, I'd say maybe 50, maybe 100 times. And I've thought about all sorts of structures, including a family trust, which we do a lot of here, and how a person would have to declare their interests. And all I can tell you is that it's a complicated process, because within a family trust, you may have beneficiaries that are named. You may have beneficiaries that are designated as such because they have a relationship with the trustee. So for example, in a typical family trust, you will see that the beneficiaries are my son, my daughter, a corporation, shareholders of the corporations, and things that are not necessarily named. And so that brings up a question as to whether or not these people would have to be actually listed. Every son, every daughter would have to be listed. I've struggled with that question. I think there are a number of my colleagues that I've talked to who have also struggled with that question. But we are at one point, lawyers are going to form some kind of an opinion about what needs to be disclosed and what doesn't need to be disclosed. And eventually this thing's going to go to court, and a judge will decide whether or not our initial opinion was correct or incorrect. This brings me to another point that I've sort of been waiting for questions to come out to tell you. And, there is this thing we have in a lot of our laws called anti-avoidance clauses. So these clauses say that, you're not supposed to structure your transactions in a way to avoid a tax, for example. Let's just look at the additional foreign property tax, for example, of 20%. There's anti-avoidance clauses in there. It says that you can't, go find a Canadian resident or do some other scheme in order to avoid this tax. If we find out that you have created a scheme simply for avoiding the tax, we will assume that scheme didn't exist and we'll still tax you. Okay. Interestingly enough, there isn't an anti-avoidance clause in the Transparency Act. So there's nothing in there that says, if you structure things in a complicated way to avoid transparency, we'll come after you. There will be penalties. There will be consequences. No, we don't have that. So that opens up the possibility for structures like family trusts to be used, and for lawyers to come up with opinions as to what structures you can use in order to provide privacy to somebody. But then privacy will come at a cost, because all of these structures will have tax consequences, will have control consequences, will have estate planning consequences. And so it won't be just, and it'll be costly to set them up to begin with. So it's interesting to note that there is no anti-avoidance structure in this act. And so I expect that we will get requests from folks saying, look, before the deadline comes, I would like to change my structure. And what are my options? I think that's a reasonable question to go ask a lawyer, and the lawyer can discuss those options. But it's not something that I can give you a cookie cutter answer to, because it really depends on the client and their circumstances.
Okay, so the other portion of Christine's question had to do with cooperatives, where there's a group of shareholders own the entire property. They don't own it individually. Right.
Okay, so I'm not familiar with cooperatives. I would have to take that question and look into it. But if they own shares of a corporation, then their identity would have to be disclosed.
Yeah, even if it's a cooperative corporation. I don't think the legislation distinguishes between one kind of company
right.
and another. Yeah,
I'd have to look into that, but my first instinct is that I don't think I've seen a distinction.
Yeah. Okay.
Right.
So question from John. The owner sells the property and gives the new owner a take-back mortgage. Does the previous owner become a beneficial owner of the property after the title has been transferred due to the fact that he or she is helping the new owner to finance the purchase of the property.
No, they're simply a lender.
Okay, the same question as the other mortgage question about who's behind it, a guarantor. That's essentially what they are. Yeah.
Right.
Okay. Let me see here. Don't want to repeat questions. Okay, here's one that we spoke about. If the transparency registry is not necessarily correct, how do you recommend we close off our own liability as to that information not perhaps being 100% reliable? I would think there would be a disclosure we could get clients to sign to release our own liability. What do you recommend?
Right. That's a good question. And I think that's something that a lot of us are struggling with. I think it's going to depend on whether or not the search output tells you what certification was provided as to the accuracy of the information when it was originally filed. Because when we are filing it right now, we can pick whether or not the certifier has checked the accuracy or whether they are not sure about the accuracy. So I think it depends on whether that information is available to you when you're doing the search. And I hope it is, because I think it makes sense if the certifier says, I haven't done everything that I could possibly do to make sure that these are all the shareholders. There could be other shareholders out there that I'm not aware of, right? Then it's not as a reliable piece of information. I think that one of the things that was raised earlier, which Harriet had brought to my attention, was that FINTRAC is going to be asking you from July to do a beneficial owner search, and she and I discussed, what do you do in other provinces where you don't have a transparency registry? And I said, well, you can get a declaration from the person that's listing the property with you that says, I swear that I am the sole owner and there's nobody else that's a beneficial owner. So I think you could potentially get a statutory declarations or an affidavit or some kind of a declaration from your clients telling you that they are the beneficial owner and the registered owner, and there's no other owner. So that you can basically, if a claim comes forward against you, you can use that as defense, saying, look, I did all the things that I possibly could do. And I think some of these best practices are going to develop over time, with guidance from the board and your brokerage as this functionality gets rolled out and people become more aware of what's available to you and what's not. So those are very good questions. And all I've given you, I understand, are a range of answers, but we'll find out the answers to those as the system gets rolled out and we find out more about what's available.
Okay, can we get a copy of the information being filed from the lawyer directly when we are acting for the buyer?
So yes, absolutely, because the lawyer can provide that to the buyer. The buyer is the client. And you can ask the buyer if they want to provide a copy to you directly. The lawyer technically cannot provide it to the realtor, but the lawyer will provide it to their client, and the client can provide it to the realtor if they want to.
Okay. Is it a firm date that April 30th is that the transparency registry will be open? Will this be a trend across land titles offices across Canada? Just talk about that.
Well, I think that I last heard, and I last heard an update on this about a week ago, that they were on schedule. Obviously, with COVID, certain things have gone out of the schedule, but as of last week, I heard that they were on schedule to release April 30th, the public search function of it. And I think it'd be very interesting because everybody will go on there and start searching for different names, famous names, see who owns property here. And I'm sure lots of articles will come out about celebrity names. But will it be a trend across Canada? I don't know. That's something that's for politicians to decide. It's a difficult registry to administer, and I think everybody will look to BC to see what their experience has been like and decide what to do.
Well, the one thing I'll add to that, the federal government, as part of its election platform, last time and has reinforced it recently, the Minister of Finance has said this, that they will be looking to have beneficial ownership tracked across the country. I have no idea how they plan to do that because they don't have any registries like we do. And that is part of, and you said, part of the new FinTrack rules that are coming in for June 1st this year. So probably there will be similar things elsewhere. It might be done differently, but the feds have talked about doing it. So they'll have to get the cooperation of the provinces who run the land registries. But somewhere along the way, it will probably become a requirement. Okay. Okay, from Beth, I just want to confirm that shareholders of a corporation do not have to give consent to the sale of a property that the corporation owns.
That is correct from where you stand as a realtor. Okay, now among themselves, they might have an internal agreement that say that they have to give consent. Okay, and it would be prudent of you when you're dealing with the director to say, look, make sure if there's an internal agreement that you deal with it. But from where you stand as a realtor, where the public stands when they deal with a corporation, they deal with the directors of the corporation. They don't deal with the shareholders. So whatever internal agreement they have amongst themselves, it's their job to make sure it gets administered. It's not your job to worry about.
You usually get some evidence of who's allowed to sign for the corporation, who's allowed to
Yes.
bind the corporation, right?
Right, and that evidence typically is the notice of articles that is filed publicly.
Right, in the corporate registry.
Right, in the corporate registry. And so you have the list of directors, and you can rely on a director coming and giving you instruction. Now, if you have more than one director, you better make sure that you're getting both of them to sign, because it's safer that way. But generally, if you have relied on the directors and they have instructed you, then you don't have to worry about there being shareholder that didn't consent.
Okay, so I've got a few questions that deal with the November deadline and what does it really mean. So do we need to go back and search all past clients for beneficial owners or just corporations in order to file by the deadline in November this year?
So you don't have to do anything in terms of past filing. You don't have to do anything in terms of past filing. Those clients have a responsibility to make sure that they do their filing. Now, if you want to be a nice realtor and out of courtesy, send them a message and say, look, you know, there's this thing called Transparency Registry, and if it applies to you, make sure you file before this deadline. You can do that, and I suggest you keep your message really short and just basically refer them to a lawyer or a website with more information and say, look into it to see if you must file. Now, one thing we do know, if they are a corporation on title, they must file. And so again, you don't have to do that filing for them. You wouldn't even have access to the system. They need to go through their lawyer to figure out what they need to file, do they need to file, how they need to file it, and all of that. And we can help them do all of that stuff.
Okay, so a related question, do the searches only apply to commercial real estate?
No, they apply to real property, commercial, residential, mix of both, industrial property, everything. It relates to real property, that's all.
It's more about the ownership of the property, not so much what kind of property it is, right?
That's right, yeah.
Yeah. Do I need to get the beneficial owner to sign all the documents?
So if you've got a scenario like this, where you've got a registered owner, that's John Smith, but Cassie is the beneficial owner, then yes, you need to get Cassie, the beneficial owner, to also sign everything. Because technically the registered owner doesn't have the power to transfer the beneficial ownership of the property without Cassie's sign off.
Okay, so Kate is asking, once again, what is the live date again for the registry so that we can start using it? And is there a practice in place to cover agents off from today until then? And if so, what is it?
So until the search becomes available, you do your practice as is. There's no additional tools available to you. You don't have an additional obligation to do anything else. The firm date, as far as I know, is April 30th. Now, next week they could come out and say we've decided to delay it, because of COVID. But as of last week, from what I understood, it was on schedule. So it's not until April 30th that you need to do anything different.
Okay. You mentioned for your own clients, you were keeping track of deals that were done after November 30th last year, but that's you. Not everybody has to do that. Is that correct?
Exactly. Right.
Okay. Got a lot that are kind of related. They're very similar. If the listing agent gives you a transparency registry search, do I, as a buyer's agent, have to do one?
Sorry, I think my headset battery ran out. Can you hear me?
Yeah, talk loud.
I can't hear you. Let me give me 1 second. Let me. Hang on 1 second. Okay. Let's see.
I can hear you.
You can hear me?
Yep.
Okay. Okay, sorry. Can you repeat that question?
Yeah, if the listing agent gives you the registry search, do I, as a buyer's agent, have to do one as well?
No. The same thing with, technically it may have changed from the time that the listing agent did the search. Basically, if it's been a month, if it's been a week, obviously, probably it hasn't changed. But like I told you, there is an obligation to file changes in the transparency registry. So just like the title may change from the time that the listing agent did their search, if it's been a while, do another search, because again, it's not that expensive. It's $11 for a title search, $5-6 for a transparency search. But if it hasn't been too long, you can probably rely on it.
Okay. I'm going to move your headset back towards your face. Yeah. Okay. Okay. Much better.
Okay.
That's
Okay.
Yeah.
All right.
Better. So Rex is just checking. So is it correct that only corporate and bare trust owners need to register, while true individuals do not have to register?
That is true. I think that's a rule of thumb that you can rely on.
Okay. Okay, Alan's shortened his words. I'm going to have to add a couple back in. There's a deal in play now from the foreign buyer with a registered Canadian corporation. Canadian seller. I am the listing or vendor's agent. So I guess he's asking, what does he have to do? Does it matter?
Okay.
Is there any difference?
So if he's the vendor, no, at this point, there is no registry search to do. So basically he has to do things as he normally does. The buyer on the other side, which doesn't concern him, has to make sure that they are doing certain filings, but they can do so with consultation of their lawyer. So he doesn't have to do anything.
Right. Okay. Iman says, Bijan, you are a gentleman and a scholar. No
Thank you, Iman.
Just a good comment. Can it make it mandatory for a listing agent to check the registry along with the title search before sending the listings into the brokerage? I guess that's a brokerage policy, right? That's about brokerage practice, I would think.
Somehow this keeps failing me. Let me just see.
Yeah.
Hang on 1 second. I'm going to sit down.
Yeah, you're not using your whiteboard anymore, so you might as well.
Yeah, so I'm going to.
Can hear you well now.
You can hear me well?
Yeah, if you just stay there,
so
you're not going to use your drawing materials.
Okay, can you tell me what the question was again?
Yeah, the question sounds like a practice issue to me. Can it be made mandatory for a listing agent to check the registry along with the title search before sending the listing into the brokerage. Brokerage practice, I assume?
Yes, that's your brokerage practice. And I don't think that our market makers are in the have the or wanting to make that mandatory. I think lawyers and conveyancers are going to probably do the search anyway, just because if we don't and it turns out that we missed something, then our client can have a claim against us. I don't think it's going to be any more mandatory than a title searches.
Right, okay. Sam, will people be able to search in the new land registry by name or only by PID number? Will this be a free service or is it paid similar to the title search?
So again, that's supposed to be ruled out, but my understanding is the public search, you can search by PID and you can search by name. And both of those are supposed to be available. I don't know whether there will be a fee for the public search or not, but that we'll find that out on April 30th. And keep in mind that that could change. You know, they may decide to charge a fee at first or not charge a fee at first and to change it later.
I think their intention is to charge a fee, but like you say, that can change.
All right.
Okay, if a registered owner is different from a beneficial owner, does the lawyer have to inform the bank at the time of funding? Can the bank refuse a mortgage at that point until the deal collapses?
So that's a good question. Let me tell you how a deal like this usually works. When a buyer comes to my office with a mortgage, let's just say their mortgage is from Bank of Montreal as an example. The buyer tells Bank of Montreal that Bijan is my lawyer. Now, technically, I would be acting for both Bank of Montreal and the buyer. I act jointly for both of them. That means that I have a duty of loyalty to both of them. I cannot hide information from either one of them. So if the buyer comes and says, look, there's this registered owner, I have to advise the bank. I cannot hold that information from the bank. But what sometimes people do when there is a transaction where they want to hide something from the bank is they go hire two lawyers. They pay two lawyers' fees. And then one lawyer is acting for the bank. Another lawyer is acting for the buyer. And then that way, yes, you are paying twice the fees, but then the buyer can tell their lawyer something that will be privileged and will be part of will not be part of the conversation with the lender's lawyer.
Okay. Can the bank refuse the mortgage?
Yes, absolutely. In fact, if you tell them that the registered owner and the beneficial owner are different, you're almost guaranteed that they will refuse the mortgage. Although, keep in mind, the bank is in the business of giving a mortgage. So probably what they would do is they would first assess that other person to see whether or not that other person, will be qualified for credit. If they are, then they'll just simply say, well, put both of them on title. Yes, we'll give both of you. Because from a bank's perspective, the more necks they have in terms.
Just lost you for a second. You still out there? Yeah, okay, I can hear you. All right, you're back. What if a director has a voting right, but the beneficial owner does not agree with the sale? So who's in power of decision making?
Sorry, Harriet. For some reason, I can't hear you.
Okay. Can you hear me now? Sound like an American, isn't it? Are you okay?
Yeah, go ahead.
Okay. What if a director has a voting right, but the beneficial owner does not agree with the sale? So who's in power of decision making?
Okay, so the director has a voting right, but the beneficial owner does not agree. Okay, so and is the beneficial owner, I'm assuming here, is a shareholder? Okay, the beneficial owner typically in our laws is somebody who has to consent. And if the beneficial owner doesn't consent, then the director is out of luck. But typically, the beneficial owner would would also have the power to appoint a new director. So that's what typically would happen, is that the beneficial owner would appoint a new director but if they don't have enough votes as a shareholder to appoint a new a director. The short answer is I need more information on that. Basically, looking at what the structure is. If the beneficial owner is just one beneficial owner and they have all the power, then the director is out of luck and can't do anything. But if the beneficial owner has less than 50% and does not have the power to appoint directors, then that beneficial owner may be out of luck. So it really depends.
You may end up in court and they'll figure it out, I guess.
Right.
If it's that bad. Okay, so Arnold, can you please elaborate on the duty of beneficiaries to register based upon either value or percentage holdings? Is it the trustee's duty to register? What if a series of trustees own property for others down the chain?
Okay. It is the duty of the trustee, not the duty of the beneficial owner to register. So, and even if there is a series of trustees down the chain, those is the trustees that have the duty. So it would be the trustees that would be penalized, not the beneficial owner.
Okay. Is the owner on title automatically uploaded to the beneficial ownership field? No.
The owner on title is a registered owner. And if there is no beneficial owner, then the registered owner is presumed to be the beneficial owner. And they're on title. And if there's no beneficial owner, there's no need to file anything in Transparency Registry. So if you search for it, then nothing should come up.
Okay. I mean, we haven't seen the registry yet, so
Yeah.
hard to say what it will look
Right.
like exactly, but yeah.
Right.
Okay. If the listing agent already has done the transparency search, does the agent need to post it on MLS?
It's the same thing as a title. I don't know if you guys post a title on MLS, but whatever your practice is behind the scene with a title search, that same practice should follow with the Transparency Registry search.
Okay. I would assume that it makes sense that when representing the buyer in an offer, you ask the listing realtor to provide both the title search plus a copy of the transparency search as a condition of the offer. Yeah. Okay.
Yeah. And I think that is the practice out there right now. When you're acting for the buyer, the listing agent sends you those due diligence documents. Again, I would think you should do your own search, because between the time they did their search and the time your client is doing their due diligence, there may have been a change. And I think that's why you have a subject condition in your offers. So you should pull your own title searches. So you should, the same way that you would pull your own, Form B strata. I think you should do your own searches. If you decide to rely on someone else's searches, that's more of a practice thing.
Yeah. So there's a question here about FinTrack. Now, I will say this myself, the FinTrack rules, the new ones on beneficial ownership, don't come in until June 1st. And we have CREA, the Canadian Real Estate Association, is working on advice for realtors the way they've done on all other FinTrack subjects. So I don't know what CREA is going to say about this. I'll reserve judgment, but this is the question. Is there a document we can add to our listing kits that shows the beneficial owner search, or are we to create our own so as to ensure this is in our paper trail? We don't know yet. CREA may give you one. That's my opinion. It seems reasonable. They've done it on other subjects. So I'd hold off on that till you hear more from CREA. And I've been bothering their lawyers to move along with their writing of their guidance. So I'd wait for that.
Right.
In fact, you know what? I'll ask them. Okay, I'll send it on. If they hadn't thought about it, maybe they'll come up with a new form. I don't know. It's a good question. What about leasehold lands owned by municipalities?
So municipal.
Lost you. Try it again.
Am I back on?
Yeah.
Okay, so municipalities do not have to file
Registry.
Try it again.
Municipalities don't have to file in a transparency registry. They're
Okay.
exempt.
It's crown land, just like all the
Right.
others. Okay.
Right.
Okay, some of these we've answered already. What happened if the private agreement just made a couple of days before completion? What happens with a private agreement? That predates the start of this.
Okay.
How do you do with private agreements at all? How's that?
So private agreements, I'm assuming they mean that it's not done through realtors, that two people privately did an agreement. So if realtors were not used, then you don't have any responsibility. But let's just turn your question to what if you've already got an offer, subjects have been removed, it's a binding offer, supposed to close in a few days, and the search opens up, and you find out that, oops, look, there was a beneficial owner that's different from the registered owner, and I think that's a complicated situation. You should still do the search. I think if you've got an active listing or an active deal that's going on that hasn't closed, you should do the search, and you should bring it to your client's attention and ask them to seek independent legal advice if the search shows that something is different. But I can also assure you that if the deal is being done in my office, that as soon as the search becomes public, and from that day onwards, we will be doing that search for every single closing. So if the scenario like that has come up where subjects have been removed, the deal is binding already, but there is some information that's come to light that shows that there may be a beneficial owner, we would deal with it.
Okay. Another question. How does this affect societies that own real estate?
I would have to look into that. I don't think that it would affect societies, but I would have to look into that. I don't know.
Society is sort of like a company, I suppose.
Right. Right.
Not really
right.
any different, but these are things we'll have to see clarified. I can't imagine they would exclude them. I'd be surprised.
Right.
It's not government, so. Okay.
Right. Exactly. Yeah. Yeah.
Okay. From Neil. Does any of this apply to a very long-term prepaid lease, say 99 years?
It could, yes, it could apply to a long-term lease. Again, I'd have to look into that one. I don't know the answer. Some of this law is fairly new,
Yeah.
and I've only had so much time to look through the act and read what I could. But these are some of the good questions that unfortunately I don't know the answer to. So I would like to get back to you on that.
Some of it may show up in the guidance as well.
Right.
I mean, this
right.
comes in some ways. If the property is owned by a municipality who may be the one you have the lease with,
right.
Then what happens, right? So, yeah, complicated.
Right.
Okay. One more question. Just like having a vendor declare, can you hear me?
Yes, I can hear you.
Yeah, okay, we've got one question. Just like having a vendor declare they're not a non-resident of Canada, can we have in the offer a declaration that the registered owner is also the only beneficial owner?
Yes, and I think you will find that your brokerage is going to start putting together some kind of a form for you to start doing that, especially when the FINTRAC requirement to confirm beneficial ownership comes into effect.
Okay. All right. Well, we're right at noon. Thank you so much, Bijan.
Thank you very much for having me.
And to all the attendees for joining us today. We had a large number of them, pretty close to 500.
Wow.
So to all of you, we'd love to hear your feedback from today's session. When you log off, you'll get a pop-up link to our event survey. Please send us your thoughts by completing the survey. Your PDP credit will automatically be processed after the webinar. So there were some questions about that. This will be reflected on your record in the next 5 to 7 days. And watch for more webinars on this topic as we know more about some of the details that are coming. Even without that, you guys asked a lot of really good questions. So we'll keep track of those. And thanks again for participating today, and enjoy the rest of your day.
Okay, bye-bye.
Thank you, Bijan. Much appreciated.